This week, we'll learn administrative law and why it is important for educational administrators in terms of the governance of educational institution, the implementation of educational policy, and the management of regulatory issues in education. First, what is administrative law? It is a body of law that governs the administration and regulation of both federal and state government agencies. It involves the procedures under which those agencies operate, as well as the extent to which they have authority over certain matters. You can consider administrative law as the body of law about government agencies' decision-making. A good understanding of administrative law can help educational administrators follow correct procedures, avoid abusing their power, and make wise decisions by striking a balance between conflicting forces, individual rights, and public interests. In the educational sector, administrative law plays an important role in shaping how educational institutions operate. It governs a wide array of activities, from the accreditation of schools, the implementation of educational standards, to the management of federal and state funding for education. For example, laws such as Individuals with Disability Education Act are administered by agencies to ensure that students with disabilities receive free, appropriate public education in the least restrictive environment. Administrative law oversees the enforcement of those regulations, guarantee the rights and services to students with disabilities. This is why lawsuits about IDEA are typically required to go through an administrative law judge before proceeding to federal court. This process is part of what's known as exhaustion of administrative remedies, a principle of administrative law that requires parties to use all available administrative procedures to resolve their dispute before seeking judicial intervention. The IDEA itself mandates this process, reflecting a preference for resolving disputes within the specialized framework established for special education, which is designed to be more accessible, less formal, and faster than the court system. Administrative law intersects with almost every aspect of educational operations, from the drafting and implementation of institutional policies to the day-to-day management of student and staff affairs. Understanding administrative law enables educational administrators to navigate legal requirements effectively, make informed decisions, and advocate for changes that enhance educational outcomes. Here, I'll introduce cases that's relevant to administrative law in education. The first case is last year's ruling made by the U.S. Supreme Court regarding the U.S. Department of Education's Student Loan Forgiveness Program. In Biden v. Nebraska 2023, the central question at hand is not whether action should be taken regarding student loans, but rather who has the authority to forgive student loan debt. In my previous videos discussing school COVID policies, such as mask and vaccine mandates for students and school employees, we saw that most of those policies were upheld in courts due to the broad emergency powers invoked under an emergency declaration. However, once the emergency declaration expired, the same COVID policies often did not hold up in court. A similar issue of separation of powers arises with the student loan forgiveness policy amid the national emergency of the COVID-19 pandemic. The question at stake is who holds the authority to forgive $460 billion of student loan debt? Is it Congress representing the legislative branch of the government, or is it the U.S. Department of Education, which forms part of the executive branch? The Higher Education Act of 1965 governs federal student loans. The act authorizes the Secretary of Education to cancel or reduce loans in certain limited circumstances. The Secretary may cancel a set amount of loans held by some public servants. He may also forgive the loans of borrowers who have died or become permanently or totally disabled, borrowers who are bankrupt, and borrowers whose schools falsely certify them close down or fail to pay lenders. In this case, the core issue is whether the Secretary of Education was authorized under the Higher Education Relief Opportunities for Students Act of 2003, also known as HEROES Act, to significantly deviate from existing student loan statutes to initiate a forgiveness program erasing about $430 billion in debt. The HEROES Act provides the Secretary with the power to waive or modify any statutory or regulatory provision applicable to the student financial assistance programs as the Secretary deems necessary in connection with a war or other military operation or national emergency. Specifically, such adjustments are permitted only to the extent necessary to ensure that beneficiaries of student financial aid are not financially disadvantaged due to national emergencies. In response to COVID-19 pandemic winding down in 2022, the Secretary of Education used the HEROES Act to propose reducing or fully forgiving federal student debt for the majority of borrowers. This move was contested by 6 states, including Nebraska, Missouri, Arkansas, Iowa, Kansas, and South Carolina, leading to a nationwide preliminary injunction by the 8th Circuit Court of Appeals. In a 6-3 decision, the U.S. Supreme Court held that the HEROES Act does not grant the Secretary of Education power to rewrite the statute to the extent of nullify existing laws and replacing them with completely new ones by canceling $430 billion of student loan principal. Justice John Roberts delivered the court's majority opinion. He wrote, while Congress specified in the Education Act a few narrowly delineated situations that could qualify a borrower for loan discharge, the Secretary has extended such discharge to nearly every borrower in the country. It is highly unlikely that the Congress authorized such a sweeping loan cancellation program through such a subtle device as permission to modify. The Secretary of Education argued that the HEROES Act's allowance for him to waive legal requirements in addition to modifying them give him broader authority. However, his use of the waiver power in this case does not align with past uses where it was used to negate specific legal obligations. The Secretary of Education also suggests that the combined power to waive or modify laws would let him reduce obligations to any extent, even beyond the limits of modification. However, the Challenge the Loan Forgiveness Program exceeds even this interpretation. Essentially, the Secretary of Education rewrote a section of the Education Act by nullifying existing laws and replacing them with completely new ones. In this case, the Secretary of Education's $460 billion debt cancellation plan is not a waiver because it augments or expands existing provisions dramatically. It is not a modification because it constitutes effectively the introduction of a whole new regime. And it cannot be some combination of the two because when the Secretary seeks to add to existing law, the fact that he has waived certain provisions does not give him a free pass to avoid the limits inherent in the power to modify. However broad the meaning of waive or modify, that language cannot authorize the kind of exhaustive rewriting of the statute that has taken place here. Here is another case about a school district's failure to follow state regulations on how to use state funds. Poway Unified School District is in San Diego County, California. The school district serves about 36,000 students. In 2014, the school district constructed a new elementary school with a hefty price tag of $82 million, funded mainly by special taxes from local homeowners. Fast forward to 2016, California voters passed Proposition 51, which authorized the state to sell billions of dollars in general obligation funds for education purposes, including student facility projects. By 2019, after Proposition 51's approval, the school district received a substantial sum of over $27 million from the state, intended to cover some of the costs initially funded by the local taxpayers. With the construction already completed, the school district had to decide how to use this reimbursement from the state. The school district's associate superintendent presented a proposal that recommended splitting the $27 million with 45% going towards community facilities and the remaining 55% for urgent capital projects. Within that 45%, about $6 million was earmarked to pay off some of the local taxes used for funding the construction. When a school board member raised questions about the legality of this plan, the associate superintendent reassured the school boards that it complied with the rules. The school board voted 4-1 to authorize the recommended allocation of the state funds. The school board member who questioned the associate superintendent on the legality of fund allocation was the single dissenting vote. 2 local homeowners challenged the school district's decision, arguing that all of the state's $27 million should have gone to pay off the local debt as per the California Code of Regulations. Their lawsuit claimed the school district failed to follow those regulations, but initially, the trial court ruled in favor of the school district. Upon appeal, the Court of Appeal found the homeowners' arguments valid, reversing the lower court's decision. California's Education Code has a section devoted to school bonds, in which rules for school bond-related legislative schemes are outlined. The State Allocation Board created a rule stating that when a school district spends local bond money on approved projects under the Leroy F. Green Act and then gets state school bond money to cover some of those costs, the money received must be used in specific ways. The school district argued that a regulation under this act was vague, suggesting they had more flexibility in using the funds. However, the Court of Appeal disagreed, stating that the language in the regulation clearly laid out 3 options for using state reimbursed funds. The list is mandatory, directing the school district shall be limited in how it uses the school funds. If the school district wanted to use the state funds for other projects, the projects must be approved, as the language as permitted in means a restricted exception to the mandated use of state funds. The school district also argued that an audit supervisor at the Office of Public School Construction confirmed in emails that the school district was not required to establish a savings during construction before spending grant funds on other priority capital projects. The Court of Appeal noted that, according to the general provisions of the Green Act, the Office of Public School Construction, which is part of the Department of General Services, assisted the State Allocation Board in administering the school facility program. The opinions offered by employees from the Office of Public School Construction were irrelevant. Their opinions did not represent the State Allocation Board's official position on the statutory construction issues. The Court of Appeal concluded that it was a direct violation of several statutory provisions for the school district to receive $27 million state funds, but allocated only $6 million to build approved projects and spend the rest on whatever capital expenditure it wanted. In this case, the school district made a critical error that the school administrators placed undue trust in informal communications, such as an email from another administrator in the Office of Public School Construction, rather than relying on the precise language of regulations and statutes. Verify informal advice. While advice and interpretations provided by colleagues or other administrators can be helpful, they should always be verified against the official regulatory language and legal advice. Informal communication may not accurately represent legal requirements or may oversimplify complex issues. Before making significant decisions based on advice or interpretations received through informal channels, it's important to consult with legal counsel. Legal professionals can provide authoritative interpretations of statutes and regulations and help ensure that the school district's actions are in compliance. Administrators should also develop a solid understanding of regulatory language relevant to their operations. This includes being familiar with the laws and regulations governing the use of funds, which can help prevent reliance on potentially inaccurate informal advice. Educational administrators' work is intricately tied to administrative law, as illustrated by the two cases I introduced in this video. A good understanding of administrative law not only ensures compliance with federal and state regulations, but also helps you navigate legal landscape effectively.